So, what happens when there's been destruction of matrimonial assets? How does that affect how the assets are to be divided up on divorce? Well, in considering how to divide the assets, courts generally won't be interested in the behaviour of either spouse. But there's an important exception to that. If that behaviour has adversely affected the financial resources, then that can be taken into account. For example, if the marriage broke down because one spouse was a compulsive gambler and squandered a large part of the assets, that certainly could be taken into account. But the exception is broader than that. In the case of Bremner, reported in 2000, the wife's conduct and that of her boyfriend caused the husband to become ill, and that forced his retirement from work, and that caused a dramatic deterioration in the matrimonial assets. And for some years, the wife had taunted her husband, drank to excess, and associated with other men, and that caused him to develop a depressive illness. Now, on appeal, this conduct by the wife was held to be very relevant in justifying an unequal division of the assets, because basically that behaviour had caused the assets to be significantly diminished. Now, in a 2001 case called Gray, the husband failed to support his wife and family after they separated, including failing to comply with court orders for financial support. And that caused the financial resources to fall, and that too justified an unequal division of the assets. Now, in a case which I actually was involved in, it's a case reported in 1997 in Stranraer Sheriff Court called Collins, the husband had multiple sclerosis, and he offered his wife a capital sum in exchange for the family home. And for various reasons, the husband's loan funds were late, and he could only pay the capital sum after the date that had been agreed, and the wife refused to accept it. And because of his condition, the husband was unable to get a subsequent loan, and Sheriff Smith in Stranraer held that the wife's behaviour was relevant and gave her less than half of the matrimonial assets. In the case of Short, it's a 1994 case, Mrs. Short forged her husband's signature and obtained large loans over the family home, and then just squandered the money. Now, the court in that case deducted the loans from her one-half share, and hence again made an unequal split. Now, by way of contrast, there was a 1996 case called Russell, where the wife, after separation, had spent a large amount of cash travelling to and from Turkey. She'd met a man in Turkey and had lost a lot on various failed businesses in Turkey. And the court took the view that losses arising from bad luck or poor business acumen are not relevant when dividing the matrimonial pie. So that kind of suggests that where you're looking at destruction of assets, there needs to be something quite close to deliberate destruction of assets for that to be relevant.